If you look at the Fifth Amendment, you'll see that it's pretty much broken down into 5 parts. You're going to have the grand jury requirement, the indictment requirement, and that's going to be interpreted not just for capital crimes. It's going to be interpreted for felonious crimes, felonies, anything that's a serious crime.
Well, I've often heard that the grand jury is sort of a rubber stamp process. What's the grand jury all about?
Okay, so as far as grand jury here in Texas, that's what we're going to talk about. It's not incorporated. That portion of the Fifth Amendment is not incorporated. We talk about what incorporated means. When the Civil War came about, we wanted to enforce the southern states to comply with the Constitution and give certain civil liberties to people that otherwise would not have had them, otherwise known as a freedman. Okay, we wanted to make sure that the states complied with the Constitution and gave these rights and followed, and we kind of wanted to establish kind of a union of we wanted to bring our states back together and establish some kind of glue. So we had the 14th Amendment. It incorporated, that means it incorporated certain rights to the states that were in the feds, because before that, the federal Constitution probably did not apply, on a large scale, did not apply to the states. So when we talk about incorporation, the grand jury requirement is one of these 5. It's the grand jury, double jeopardy, self-incrimination, and the due process and the takings clause. We're going to talk about all 5 today. But as far as the grand juries, that one's not incorporated, and you had the state level. On most states, even though it did not apply to the states, most states, other than I think it's Pennsylvania and Connecticut, have grand jury clauses. Back in the day of the founding, and this goes directly to answer your question. In the day of the founding, this was important because you would have a grand jury of people that were local, and you may have some kind of violation of a offense that was promulgated, that was made or created by the crown, okay, or parliament, and that didn't really apply to the colonies. And so a lot of times they'd use the Stamp Act, things that there weren't representation on, that weren't looked at favorably from the local standpoint. So the grand juries played a very important role in the day of the founding, because they were able to say, we're not going to indict a local brethren for a violation of this dumb stamp tax act that we didn't have a right to even talk about over in England. They tried to apply there today. But today,
now that Stamp Act, that was what brought the Boston Tea Party on.
Yeah, it was all together, exactly. We had taxes on stamps. We had taxes on tea and other exports, imports that we had no right to say. We talked about the quartering acts. The quartering acts allowed soldiers to stay in your own place, which was another form of taxation.
So those taxes weren't applied to goods in England?
No, it was applied only in the colony states, and so that's why this was such a big push. Why are you applying it to us? And we don't have representation about whether or not they go into effect, and how do people in England know about the local environment? How do they know what it costs to run a business here in the colonies? How do they know what it costs to run ships?
We had no voice in Parliament then either.
Correct. Okay. And so to pass these acts, and it wasn't just taxes, but those were big things. Okay, but those to violate some of those laws were looked at disfavorably. To say that a local person in the colonies violated those things were looked at disfavorably in the commonplace to the common people. And so these grand juries would step in and essentially stonewall, right? I would say now it would be the equivalent of a federal prosecutor, which would be the representative of the crown, coming in and saying, we're going to get you indicted for violation of the stamp tax, the Stamp Act, and or any other kind of promulgation, any other kind of regulation that was made, right, from Britain or England at that time. The grand juries would step in and prevent that from happening here. Then fast forward a couple centuries, and here we are, and we have a bologna sandwich. So, in other words, it's a famous joke that a prosecutor can essentially get a ham sandwich indicted, and if they wanted to. And we did have some grand jury reform. I don't want to say that the grand juries play absolutely no role. Oftentimes we can submit a grand jury packet. If it's the right case, if it's a questionable case. We also had several cases that we talked about on here where grand juries actually get the DA out of hot water. Okay. Right? A lot of times the district attorney doesn't want to bring a case. A lot of times it's in a self-defense case, say, but that was maybe halfway questionable, or that maybe it was a good self-defense case, but maybe it was an unfavorable person that used the self-defense against a really favorable person in the community.
Okay, so the DA has to do something.
He has to do something because it's like, oh man, I got a bunch of people complaining. So they go to the grand jury, submit it to the grand jury, and all this is secret, right? So unless you've been a prosecutor, unless you've been a felony prosecutor, it's hard to have knowledge unless you've been a prosecutor or also on the grand jury. And so, but essentially there's no regulations, there's no procedure, or at least there hadn't been for a long time, and there's still really not anything set in stone about what procedure you use to present your case to the grand jury, which is both dangerous and favorable, right? Because they could present it in such a way, man, this guy's guilty, I've been dealing with this guy forever, I'm getting tired of him, I may not have a good case here, guys, but he's dealing dope, and I think you guys should just charge him with this so that I got leverage.
Okay.
And they may indict him, but from the other standpoint, he could go, man, I've got no choice to bring this. I don't want to bring this case.
The evidence is weak, maybe.
It's weak, and I don't really like the way this is presented. It's just I got a lot of back on my back, and I'm just hoping you guys do the right thing.
Okay.
Kind of thing. And so,
Sure.
so the grand jury can play a very important role, especially from a political standpoint. They can help calm and quell, outcries to say go after somebody when it's really not just to do so, and the district attorney can use that as a device to prevent injustice. The district attorney can also use it as a device for injustice on the other side, right? To go after somebody that doesn't need to be used for. But all in all, I think it still plays some kind of role. I think at the end of the day, they do no bill people. They do no bill, and it's not all for political stuff. Sometimes the district attorney brings that we talked about, and I've got his permission, Harold Weezer. We talk about Harold Weezer's case from Rosebud, where he flicked off the police officer, drove by after several outlaws. It was outside the police officer's authority, okay, and they ended up, I think, storming his house with SWAT and everything, and charging him with aggravated assault with a deadly weapon on a police officer. It would have been a first-degree felony.
Yeah, Harold's a friend of mine, and I don't know if you know it, but just yesterday, Court of Appeals, the United States Federal Court of Appeals, says that free speech involves holding up your middle finger at a police officer.
So
So Harold was way ahead of his time. Congratulations, Harold.
But to that aspect, the grand jury did no bill that first degree felony, which was very important. And it did take the case down a notch and said and got everybody, even the government side, look, if you're going to charge them, that's fine, but you're not going to charge them with. If you think you got a case, present it, but you ain't going to come in here and go with this outlandish charges that really have no basis in law or fact. And so I think that the grand jury at the end of the day does play some kind of role, but like you said, for the most part, they do rubber stamp whatever the district attorney wants, and I don't mind saying that. And I think probably a lot of district attorneys will tell you that.
Well, that's where I've heard it.
And so from that standpoint, that's the first part of the Fifth Amendment. And so again, even though the Fifth Amendment doesn't make the grand jury clause applicable here, and that's going to only apply in Texas as well on felony cases, it is important because it does apply in Texas because we have our own constitutional sections about this. We have our own statutes about how the grand jury operates. If you want more about that, you can also reach out, I'm sure, on Google, or even holler at me by email.
Then it goes on to talk about the military. Apparently, the military tribunal.
Obviously, court martial and the militia. If you got a state militia, the state reserves now probably would be the equivalent to that. They're going to have their own procedures. They're going to have their own process. We're not going to make that apply. But if you're talking about just on the federal level and a federal court procedure, you're going to have to be indicted for a serious felony.
Okay. So there's double jeopardy. I've heard a whole lot about that through my years, and I've kind of wondered because I'm seeing what I think to be kind of a watering down of that right, because I've heard of people getting tried for a situation, then what seems to be the same set of facts, they get tried for a lesser offense after they're found innocent of the first offense. Tell us about that.
I'm not going to. We talk about how much we avoid this, and when you talk about how much it's been watered down, you're absolutely correct. It's definitely not what it used to be. It does not have the teeth that it used to be, nor do any of the constitutional amendments really to that effect. But it's so complicated. It has gotten so complicated that scholars on both sides of the issue in both camps could disagree. But from the general standpoint on your double jeopardy is you're not going to be put in jeopardy of a criminal conviction, of a guilty conviction, more than once. And a lot of times what would happen is let's say in the day of the founders, right, you would get tried over and over and over and over again. Okay, and not only would this have this psychological effect on you, but it would have an economic effect on you.
Oh, absolutely.
And you would essentially bring down businesses, okay, because they would spend all their money litigating with the government instead of, right, spending it towards their business, and they would go out of business, and so the government would get the outcome that it wanted, even though it didn't get a criminal conviction. And so what the framers here are trying to do is prevent both psychological and economic, right, injury. They don't want you to just be tried over and over and over and over again. However, they developed different standards now that if it's got one element that the other one did not, and when you talk about elements, so it would be like if it was burglary, a standard burglary, it's just a breaking and entering of a habitation, okay, at nighttime. Okay, and so each one of those things, okay, with the intent to commit another felony therein, okay? And so each one of those things is an element, right? Each one of those things, breaking, entering, habitation, nighttime, specific intent to commit another kind of crime.
And they don't have to try all those at the same time. They can split them up.
They can split them. What do you mean by that? What do you mean?
Well, we can have one trial for where it involves some of the elements for some crime, and then, well, okay, you think of somebody who's charged with murder, or not murder, a homicide with a deadly weapon when they're drunk and driving a car.
Okay.
They go to trial, and the jury says, no homicide. Can they then be retried for DWI?
So traditionally, I would have told you absolutely not. I would say that the DWI was encompassed, right, within the because you would have had to have been driving the vehicle, which would have been your deadly weapon. They're saying that it was, right. It depends on. So normally, yes, I would have said that would have been subsumed. It would have been encompassed by your larger case. The DWI would have been encompassed by your case of homicide. But now
it would seem to me that that's what double jeopardy is all about. But go ahead.
But now, what if they never did make an allegation about you being intoxicated from using the vehicle?
Okay. If they did not make that allegation?
If they did not make that allegation.
Okay, what if they submitted the proof?
Then I would say traditionally yes, but now the courts are sometimes saying, and I'm telling you, I don't even feel comfortable giving you a definitive answer on any of this.
Well, I understand.
Because it's so hotly contested right now. It's actually a hot topic, right? And so you would have probably some courts tell you that there was an element within the DWI that wasn't an element that required proof on the homicide trial. And so because one required an element that the other one did not, then it would not be double jeopardy. And they could come back and try you on the DWI. I think a lot of courts would tell you, no, there's no way. That's absolutely, that's what the proof was, is that he was reckless or that he was indifferent to life because he was intoxicated at the time. I just think that it could go, all of these cases, you never know what you're going to get with a double jeopardy claim.
Well, in Texas, the high court is the Court of Criminal Appeals with regard to these matters, right?
Correct, but they haven't spoken on a lot of these matters.
What are the two kinds of errors that they recognize?
Absolute reversible error, and then just does it affect your substantial rights?
Well, I've heard the two kinds is the harmless error and the error that was not
reversible.
Yeah, well,
or constitutional.
The one that was not mentioned by the lawyer in the court. Yeah, the two kinds of errors that really don't matter. In other words, they uphold the conviction.
Yes. Okay. Again,
that's
I got
the Court of Criminal Appeals in Texas. So that's why you're having a difficult time talking about it. Okay, so on television, we've heard over and over again, you have the right to remain silent. Anything you say can and will be used against you. Now tell us, Ross, real short, and then you can elaborate. What should we do when we hear those words spoken to our face?
I think there was a good Facebook out by some lawyers in Vegas. There was a lot of people have been seeing, and their whole thing to the title to their little video that they did was "Just Shut Up."
Just shut up. Okay, sounds like.
So I think that gives you a really good idea about what you should do, how you should use this Fifth Amendment right, and it's definitely something that should be used a whole lot more than what.
And when you get to the jail and your wife comes in and asks you what's going on, what happened? What should you do there?
You should. Technically, with your wife, you're going to have a privilege. You're going to have a spousal privilege, okay? But they're going to record. They're going to record you, like what Rick was. Like we were about to say at the exact same time. They're going to record you, and they're going to have on that recording that it's being recorded, and you are submitting and giving consent to us for this recording right before you do talk to them. So, in that effect, it's not going to be privileged anymore, and they're going to be able to use that recorded conversation. Also, if your wife comes to see you at jail and they don't have the pre-recording before she talks to you in the phone through the booth, I assure you that they're going to have some sort of sign. They're going to have a sign either in the hallway before you get to the room. They're going to have the signs out in the room where you're talking. They're going to have the signs out on the wife's side somewhere. They're going to have a sign somewhere telling you that that all of the conversations are being recorded. Even if they don't have the sign, I'm telling you, you need to be careful about what you say in those conversations, because I can tell you, I have lost cases before the cases ever got started for what people have said on the jail recordings. Okay, and so just be careful about what you say. I hope none of the listeners are going to go to jail. But I'm just telling you, maybe if you got a loved one that's in there and he's trying to tell you about what happened over the phone, maybe you say, look, I listened to Benton Watson on the radio this morning, and he said that maybe we shouldn't talk about this right now. Okay, and so, that's something I can't stress enough. I'm glad you brought that up. I wasn't even going to talk about the recorded phone calls at the jail, but absolutely, you got to be careful. And then, hey, depending on what kind of case it is, the love of your life could be trying to set you up, right, on those recorded conversations. And so just be on the lookout for that in a family law case to come in the near future.
Can the love of your life waive the privilege, or do you have to waive the privilege?
Depends on what it's about. If it's going to be about a family violence or something that happened within the home or to that effect, then obviously that privilege is not going to apply to her. She can waive that. But if it's going to be about some kind of communication that you made to that spouse that is relating to a crime that's just happened to be part of conversations you had with your significant other, then you can invoke the spousal privilege, which means you can prevent your spouse from testifying.
Okay. So what else you got for us on self-incrimination?
So on self-incrimination, here, this is what we talk about when somebody says, they call in and says, well, he didn't let me talk to my lawyer, or, they didn't read me my Miranda rights. I get that all the time. I mean, people call in all the time, right, with some sort of problem. They think that they want me to get their case thrown out because the police officer didn't read you Miranda.
Technical oust.
Yeah, so that's going to be, you have the right to remain silent. You have the right to an attorney. If you cannot afford an attorney, one will be appointed to you. You have the right to terminate questioning at any time. Okay, those are going to be that when you read you your Miranda, those are going to be the rights that I'm talking about. And here's the thing: Miranda's not going to get your case thrown out most of the time anyway, even if it's violated. All Miranda's going to talk about is statements, testimonial statements by you that will be used as evidence in your trial. So let's say that you get stopped and there's evidence of marijuana. He smelled the marijuana. Maybe the dog hit. Maybe they never even asked you. Maybe we're not even talking about any statements, but then they got the marijuana. They found it right there in the console of your truck because you weren't smart enough to put it right under the seat or anything else. Right? And you left it right there, or maybe burn it in the ashtray. Okay, and so we're going to take that and we're going to use that to prosecute. Nothing about Miranda is going to affect any of that physical evidence. That would be something you would be hoping for the Fourth Amendment to come in and help you out.
That's kind of a different sort of self-incrimination when you leave it burning in the ashtray.
What self-incrimination might be, and we're going to get into, I'll start with the issues. And it really doesn't affect it, but I'm going to start with what it could affect. Is what you say. So if you say there's the marijuana burning in the ashtray. That's it. Does this, the issue is going to be, does that statement, because that's incriminatory, right? That actually incriminates you and shows that that was yours. You knew where it was. You obviously were in control of it because it was in maybe your car. You had knowledge about what was going on, the confines, the scenario within the environment itself. You had knowledge about what the environment was. So you're trying to throw that out because you want to say that blunt was the passenger's. Okay? Now I've got to figure out a way to make Miranda come into play. Well, I'm not probably in that scenario. Roadside questioning in a DWI situation. You get stopped. He's asking about DWI. Right? That has been by law, by the courts. I don't know why. I don't necessarily agree with the ruling in all respects.
But I only had 2 drinks.
Exactly. They'll tell you that everybody says 2 drinks, so maybe you want to think about a different way to say that. And I will tell you, a lot of people do say 2 drinks.
On that, the prosecutor tells the jury he said he only had 2 drinks, and then he laughs, and all the jurors laugh.
So you gotta be careful about what it is that you say. But if you say 2 drinks, right there, right away, you're giving the police officer a reason to think that you're somewhat intoxicated. And remember, you don't have to be .08. You do not have to be .08 to be intoxicated. The police officer can make his own determination, his own opinion, right, that you have lost the use of your mental or physical faculties. Okay, and so you don't even have to be a .08. And with that being said, the police officer could still get probable cause to arrest you for a DWI even with 2 drinks. Maybe you're a person that has some kind of extra effect to alcohol that others don't. Maybe you're somebody that has a health, right, some kind of health condition that makes you more susceptible to the effects of alcohol. Maybe you're a person that's on another kind of medication that makes you more susceptible to the effects of alcohol. And so that officer can still say, and I'm not saying he's going to win at jury trial, but we're not talking about that. I'm trying to save you from getting arrested. Okay, but if you're telling him 2 drinks, that may be enough to give him probable cause depending on the circumstances. Now, if the video shows the guy's walking fine, talking fine, absolutely. I've had a police officer say on tape before, I don't know what the police officer was thinking. He said, you're walking fine and talking fine, so why are you saying you got all these problems? Well, I used that against him in a motion to suppress. So you said he was walking fine and talking fine, so then obviously he wasn't intoxicated. Okay. Anyway, I got off on a little tangent.
That took away his probable cause. We were able to get that case thrown out. But, so police officers, if you're listening today, be careful about what you say to the DWI stop too. but you gotta be careful about what you say. And I'm gonna get to the point. I'm sorry I digress a little bit. It's ADHD in me. But we're getting to, are you in custody and are you being interrogated? So we know that the roadside questionings on a DWI stop is not what we call custodial interrogation. You're not going to be in custody and you're not going to be being interrogated. So then at what point are we in custody and are we being interrogated? Well, when they read
Seizure's easy.
Miranda rights, I think that's a pretty good ticket to.
Well, yeah, if they do read it. So if you're in the car and the police officer, whoa, man, what's that smell? You got marijuana? You say, yeah, officer, I got it right here in the car. At that point, you were never placed in custody. And so at the first instance, we got to ask, what is custody? From the Fourth Amendment standpoint, seizure is easy. Okay, seizure is any kind of like submission to a show of authority.
Yeah, they put you in handcuffs.
Well, is handcuffs only a seizure, or is that custody?
No, I would think it's both. They seize your body.
Exactly. So a custody is always a seizure, but a seizure is not always custody.
Okay.
So you can be detained. I don't know if you guys got into Terry style. I told you I didn't want to watch your
just a little bit
deal because I was so upset.
On the Fourth Amendment, yeah.
So in traffic stop situation, and I'm going to go into a little bit of the Fourth Amendment here. In a traffic stop situation, we're both looking at, right, the detention. It's sort of like a Terry stop. In Terry, he was a well-versed cop that was walking the beat of the street in downtown, see some guys walking around a building, and they keep walking around, they walk across the street, walk around a building, walk across the street, walk around a building, and they walk across the street, talk to another guy. Well, they ain't looking for the Saturday sale.
Yeah.
Okay, they're not going to the front door. They're not walking in. They're walking around the building, looking through the windows at each one. They're casing the place.
Right.
Okay, and so what Mr. Officer McFadden did in Terry, and this was in Ohio, he walks up to him, and he's like, "What are you guys doing? What are you guys up to?" And they start acting really nervous. Right? He knows one of them. Right? And then he sees a bulge. He says, "Man," and he pushes them up against the wall. Does a really quick Terry pat down for weapons because he's starting to fear for his life. He was just going to question them about what they were doing.
Right.
Okay, and so under the Fourth Amendment, when he walks up and questions those guys, that's a seizure.
Okay.
So that would be a seizure under the Fourth Amendment, and he would now have to have what we call reasonable suspicion, which is just slightly less than probable cause. It's saying there's something there telling me that there's criminal activity afoot. I can't put my hand on it. I can't say that criminal activity happened. I can't say, maybe it has happened, but I can't say for sure. But I know that there is something based on criminal activity, connected to criminal activity, that allows me to come in and at least ask a couple of questions. Very briefly. It's very brief. Stop. Okay? And it's not something that you can sit there and hold them forever just based on what Officer McFadden saw. Right? But then he saw the nervous activity with the bulge, right? And then had a reason to pat them down, which led now to the Terry pat down law. It made that's what allowed that case allowed police officer to pat you down. So
that's primarily for the protection of the officer, right?
Yes, absolutely, for protection of the officer. So there's got to be some evidence that the officer perceives to show him that there's a threat to officer safety. Okay, so taking that into consideration in traffic stops, when you actually violate the traffic law, when you speed, that's probable cause. Okay, now I don't want to get into it's a custodial arrest and things like that, but technically under the Constitution, and this was Atwater versus Lago Vista, this was a Texas case, Atwater versus Lago Vista, the lady didn't have her seatbelt on and got arrested. The police officer arrested her with her 2 kids in the car. We talked about that. It was really unreasonable, right? And so she appealed to the United States Supreme Court. The United States Supreme Court said, under the Constitution, under the common law, that's what we look at. Was it unreasonable? No, because there was probable cause to arrest her. She broke the law. She could be arrested. So, with a traffic offense, that's what's funny about this, is that there could be probable cause to arrest for a traffic offense. But we look at a traffic stop in Terry. We look at it as a detention. It needs to be no longer than necessary to write the ticket and let you go. Okay? Or if you're going to arrest them, you need to go ahead and arrest them. Okay? You can get arrested, right, for violating traffic, but that doesn't happen. But the officer's got a very short time to make up his mind. So, in that seizure, he doesn't have long to make up his mind whether you're going to be seized, right, or whether you're going to be arrested. And so then you've got to make your determination, okay, if he puts you in cuffs, is that an arrest? Probably, but not all the time, right? Not all the time, because you could be, maybe the circumstances develop really quick. The officer needs to figure out whether or not you are who you say you are, or whether or not the other person, maybe he puts you in handcuffs for his own safety, just to make sure. So that's just a detention. Okay, versus an arrest. So we're looking at, is it the functional equivalent of an arrest? And it could be because there's 20 officers, all surrounding a guy with guns. I would say that's probably an arrest. But he's not in handcuffs. So handcuffs aren't determinative, but they are persuasive.
I would say so.
If you've ever been in handcuffs, you know what I'm talking about.
They're pretty persuasive.
It's like what Clyde and I used to say, if hire us, we've been arrested. We know what we know what you're going through. So, not you. I'm speaking for myself here. but so yeah, you got to ask: are you in custody? And all these things come into play. Remember, they've got so much time to act. Well, if they go outside that scope, they're going to have to arrest you. And so I think if they continue to hold you there, right, for too long, they're going to look at that as either an arrest or an invalid detention. Okay, under Terry. So it's either going to be an arrest or an invalid detention. If they don't have a reason to prolong the traffic stop, there's not going to be a reason for them under the Fourth Amendment to justify their actions. So then they're going to have to, but if there is, then they've got a lawful stop and you're in custody. Okay, so now, then, even though you're in custody, is it interrogation? Okay, and so I know I'm getting excited about this, and it's a lot.
Well, I can tell you love it, but that's the criminal lawyer in you coming out.
Yeah, it's a lot. It's a lot, and so there is a process you go by to make sure you see these facts, and you always start with the Fourth Amendment to make sure you've got a valid stop, a valid seizure, and does that seizure escalate to custody? Once you get to
that's why you got to go to Benton Ross Watson when you have a situation like this, because he knows the steps.
Well,
we have two more out of 5 that we need to talk to in a few minutes. So
I'm going to talk next week when we get to the Sixth Amendment about interrogation more.
Okay.
And so I wasn't going to harp too much on interrogation, but is it calculated to elicit an incriminating response? Right? If you blurt out that there's marijuana or drugs in your car or something like that, you're not going to be protected by the Fifth Amendment. Okay? It's self-incrimination. You cannot be compelled. It cannot make you come to grand jury up here, right, and testify, right, to where it incriminates you. Same thing. A police officer cannot force you to incriminate yourself, and they also can't use tactics, which we're going to talk about next week in a very good case out of Rhode Island, right? Can't use tactics that are calculated to make you, right, say something incriminating. They know, right? They know that. Well, they can, right? If you've waived your Miranda, if they read your Miranda, but they haven't, then they've got to be very careful. So we're going to talk about the consequences of that right next week. But for the fourth section of the Fifth Amendment is the due process, and for due process we have both procedural and substantive.
Now I know that due process is a mighty big part of the Fifth Amendment, and that might be something that could take a whole session, frankly, because it is complex and complicated. But if we only have a few more minutes here, Ross.
Yeah, but if you remember, we had the Third Amendment, and it was quartering of soldiers, where soldiers took over their house without your consent. And so we talked about there really hasn't been any good cases litigated, but what the Third Amendment was important for is showing us that there was rights implied by design within the Constitution. In other words, the First Amendment says speech, but it doesn't say conduct. So there had to be some implication that speech was broader than just verbal.
Kind of like Harold's case, lifting of the middle finger.
Right. It involved more. There was more rights involved than simply what the Constitution said. And so procedural is going to speak to notice. Okay, did you get notice like you're supposed to under the rules? The other one is going to be substantive, right? Are your rights violated in such a way that you cannot use, right, other implied rights that we talked about, those penumbras, those rights that maybe is there some kind of disadvantage given to you by under the First Amendment, and that would allow you to also make a Fifth Amendment claim, and that would be vagueness, overbreath, right? A lot of times you can tie in, and that would be like if a statute is you can't understand what the statute's meaning is. And so because you can't understand what the statute's meaning is, you don't know what the process is going to be in order if you want to exercise your rights. And so it puts a chill on your exercise of your other important rights. And so that would be a Fifth Amendment claim under due process. Takings, we talked about, I think it's relevant to today with the pipelines.
Well, back to due process. I know that there's a lot of U.S. Supreme Court cases that imply, if you may, or apply the due process clause to a broad area of cases. In other words, due process has to be given to almost any situation involving the taking of property or the taking of assets or taking of your body.
Correct, all that. The due process is applicable in all
and that was applied in the 14th Amendment, I believe?
Both, yes. So that's what I'm trying to say. You the 14th Amendment is going to have a due process clause on it as well. You're also going to have your substantive, just generally, you're going to have your substantive and your procedural due process rights, okay, talked about. And so when you hear lawyers talk about your procedural due process, you're talking about notice and things like that in an adjudication, in some kind of proceeding. When you talk about your substantive rights, that's saying there's been some kind of law, or the law is unclear as far as exercising my other constitutional rights.
Now, this last part says, nor shall private property be taken for public use without just compensation. I know here in Milam County, we have several pipelines coming across.
Correct.
And it's eminent domain, whenever a power line goes through or a road goes through, eminent domain. Is that what we're talking about here, Ross?
Correct. So the state's going to have the right to come in and take private property as long as they pay you the fair market value at the time of the taking for that property. Now,
so just compensation, I mean, when you say
is the fair market value.
That's like, well, you know, I have a big old oak tree and I'm going to build my house there. I've been wanting to build my house there for a long time, and I'm going to retire, and I want to and they're going to put a power line right over the top of that and knock that oak. I am so upset. To me, the market value is a lot higher than market value, right?
Correct. And then you got people that are out saying, you know, I'll sell to whatever somebody's willing to pay. Well, what the Supreme Court or what a Texas Supreme Court is probably going to say about what somebody's willing to pay is what a willing buyer, non-coerced, non-pressured buyer would be willing to pay, taking the advantages and disadvantages of the property. Okay, and so what that means, who knows? That's why there's a lot of good lawyers out there that do nothing but eminent domain, and they are going to argue, right, on specific types of cases that certain property is way more valuable than what the government is saying that it is, and obviously you can have huge litigation over this.
I've been involved in some of those cases involving power lines and others involving pipelines, and obviously when you put a power line through that's got about 8 wires and these big huge towers, it's going to affect the property value of the whole of the property. You know, if you got 500 acres and it goes across the side of it, it'll affect the whole property. Whereas the neighbor who's just across the gravel road, he gets nothing, because even though the power line is sticking up right next to his house,
they haven't actually taken anything.
They haven't taken anything according to our law. So that's a tricky thing when you start talking about the whole of the property and the value lost. Anyway, that's another good place to think about getting a lawyer, because you know, the power line companies, the pipeline companies, they all want to stick it through as fast and as easy and as cheaply as possible. So they're not going to come in and offer you what you could get if you had a good lawyer. And you have these great debates, right? Because you say it's got to be for a public use, but the pipeline companies are going to make all the money. Yeah. Pipeline companies and the oil companies and the shippers and transporters are going to be the ones that make all the money. So where's the public use coming in? That's right. So the public use is going to come from the lower gas prices, because transportation is cheaper, and overall market and economies of scale kind of thing come into play. And because we can transport it to Houston, from Lubbock to Houston much quicker with a pipeline, it's going to show up at the pump. Commerce clause, I think, is what you're talking about. But that's going to say that's the public use. That's what we get. And same with the economic renovation stuff in Kello and Berman and Ross, the Hawaii cases. We're going to have another segment after tactical snacking. Would you be willing to hang in here with me and talk about guns a little bit? Yeah, sure. Okay, tell us how to get in touch with us. Yeah, if you guys, we always look questions. We get a lot of emails, been getting a lot of emails. Go ahead and email me at benton@watson.legal. That's benton@watson.legal. Make sure you leave your phone number, because I can't always get an email back to you, but it's a lot easier for me to call you sometimes. But you can call us at 254-605-4140. That's 254-605-4140, or come see me down here in Cameron at 105 East Main Street, big milk cow on the side, can't miss it, or call us for an appointment in Brazos County or down in Houston. So I look forward to speaking with you guys about the show. Thank you. My name is Richard Dodd, and you can get in touch with me by email at justice@respectforyou.com.